Hi, I'm Michelle Amico, and I'm a judge with the 18th Judicial District.
Hi, I'm Dave Furman. I'm a judge with the Colorado Court of Appeals.
Interesting legal issues arise when the witnesses or victims in a case are children, particularly when a party wants to introduce their statements at trial. So we're going to talk to you today about child hearsay motions. In all candor, we could spend a lot more than 15 minutes on this topic. Our written materials will be invaluable to you, so print those and keep them as a resource. I'm going to start by giving you the nuts and bolts about child hearsay, and then I'm going to turn it over to Dave to add the perspective of an appellate court judge and what to do when what is typically a straightforward hearing goes off the track. The child hearsay statute is found at 1325-129. The statute is designed to allow jurors to hear the out-of-court statements of a child at the jury trial, which would generally be inadmissible as hearsay if certain conditions are met. Many mistakenly believe that child hearsay statements apply only in sexual assault on a child cases. Read the statute. The statute actually allows statements of a child victim of or witness to sexual assault, child abuse, dependency and neglect, or domestic violence. So, you might be conducting a 1325-129 hearing on a sexual assault case and be considering statements a child victim made to different people, or you might be conducting a 1325-129 hearing on a domestic violence homicide case in which the child witnessed the murder and made statements about what he or she observed. And the statute applies to both misdemeanor and felony level offenses. So both district court and county court judges will deal with these 1325-129 motions. They are not unique to district court. Here is how it works practically. First, the prosecution is required by the statute to provide the defense with reasonable notice of its intention to introduce the statements at issue and disclose exactly what those statements are. Therefore, the prosecution needs to provide the statements in discovery and file a timely motion. Most judges require that all motions be filed a certain number of days in advance of a motions hearing. This is when the prosecution should be filing its 1325-129 motion. In general, in district court, these motions will comply with what is meant by reasonable notice. But in county court, the attorneys are less experienced, and a county court judge will be asked to make a finding on the morning of trial, so be prepared. You will have to ensure the statements have been disclosed and decide if this is sufficient notice before proceeding to a hearing. One reason behind the notice requirement in the statute is that you as the judge need to conduct a hearing on the motion outside the presence of the jury. The prosecution will call those witnesses who heard the statements of the child at the hearing. So keep that in mind when you set the actual motions hearing prior to trial. You will need extra time for this particular motion. In the motion itself, the prosecution will list those witnesses it intends to call at the hearing, and those witnesses will testify in person at the hearing about the statements the child made. Sometimes the prosecuting attorney will attempt to make an offer of proof about what the witness would say, especially in county court. I would caution you about ever accepting an offer of proof because you have specific findings that you need to make, and an offer of proof usually won't give you enough information to make those findings. The types of witnesses you will typically hear from include a parent, a teacher, a friend, a babysitter, a social worker, a counselor, or a police officer. In addition, you will usually be provided with an audio or video disc in advance of the motions hearing, and in fact, a good practice is to require the prosecution to provide you these in advance of the hearing so you can watch it on your own time and be prepared to fully rule at the hearing. The disc will contain the forensic interview of the child. These exist in most cases, but not every case. A trained child forensic interviewer will have conducted an interview that you can watch prior to the hearing. In most circumstances, the parties stipulate to allow the court to just use the disc and there's no need for the people to call the actual forensic interviewer at the hearing. But there are occasions where the defense might want that person available for the hearing. In order to admit child hearsay statements pursuant to the statute, the child victim must be available to testify at trial or is unavailable to testify at trial, and there is corroborative evidence of the act which is the subject of the statement. As you listen to the testimony as the judge, you will be listening to see if the time, content, and circumstances of each statement provide sufficient safeguards of reliability. That is the finding you must make before admitting each specific statement. In determining whether the time, content, and circumstances of each statement provide sufficient safeguards of reliability, case law has outlined numerous factors for the trial court to consider. The primary case often relied upon is People versus District Court. The factors are not exclusive, they are guidelines. You can use other factors if you wish, and further, all of the factors do not have to be met. You will see that the questions asked of the witnesses will usually track the factors you should use. Those factors for you to consider include: number 1, whether the statement was made spontaneously. Number 2, whether it was made while the child was still upset or in pain from the alleged abuse. Number 3, whether the child spoke in age-appropriate language. Number 4, whether the statement was made in response to a leading question or rather was in response to an open-ended question. Number 5, whether the child or the witness has any bias against the defendant or a motive to lie. Number 6, whether any other event occurred between the time of the abuse and the time of the statement which could account for the contents of the statement. And number 7, the general character of the child. Once the hearing is concluded, you can rule either orally from the bench or prepare a written order. You need to ensure you make specific findings for each witness about how the time, content, and circumstances of the statements provide sufficient safeguards of reliability. The standard you utilize is a preponderance of the evidence standard. What I suggest you do is start your ruling by referencing the statute, the standard, and the applicable case law you are relying upon, and then for each witness, go through and state the factors and your findings about those factors. Dave might have some other suggestions for you so that your ruling stands on appeal, because admission of child hearsay statements is almost always an issue raised on appeal upon a conviction. Then, when the trial actually commences, you need to remember a few things. The statute requires that a limiting instruction be provided in the final jury instructions, which advises the jurors that they heard evidence of an out-of-court statement of a child, and that it's for the jury to determine what weight and credit should be given to the statement. Further, the jury needs to be instructed that they should consider the age, maturity of the child, the nature of the statement, the circumstances under which the statement was made, and any other relevant factor. Case law requires the limiting instruction be read contemporaneous with the admission of the hearsay evidence. Thus, I always read the limiting instruction before the witness testifies about the out-of-court statements and then also include it in the final jury instructions. This makes a clean record and ensures the jurors are mindful of how to view the evidence when they hear it. With respect to the recorded interview of the child, if you found that admissible, then the whole tape, absent any evidence not permitted by other rules, is played for the jury. However, you cannot let the jury have unfettered access to the tape during deliberations. Case law directs you to have specific rules in place. It's a good idea to have counsel voice any objections they might have to the procedure that you are going to use. For example, you can instruct the jurors when you send them back to deliberate that if they want to view the tape again, they can ask for it and you can send it back to the jury room and give specific instructions that they can only play it once and give them a set amount of time to review the tape and then take the tape back. There are different ways to supervise access to the tape. Just make sure you have something in place that does not allow the jury to give undue emphasis to that one exhibit. Now I'm going to turn it over to Dave to talk about when you get derailed, and now you have to make decisions about the admissibility of child hearsay statements in conjunction with the confrontation clause.
Let me first set up an example for you. A 12-year-old female accused the defendant of repeated physical and sexual abuse. Last month, you completed a child hearsay hearing, ruling the following statements made by this child admissible under Section 1325-129. The child made statements to a friend at school, a teacher who reported the statements to social services, a social worker from the local social services department who responded to the teacher's report, a police officer who came out to the school and took a report, and a forensic interviewer who interviewed the child a few days after her initial outcry. At this hearing, the public defender objected that the admission of the child's out-of-court statements would violate the federal confrontation clause and Colorado's confrontation clause. The people expected the child victim would testify at trial, but the week before trial was to start, the child ran away from home. The school social worker and the child's mother think she ran to Mexico with her boyfriend. The child never testified. The prosecutor wants to go to trial. You stated on the record there would be no further continuances in this case. What happens with the child's statements you ruled admissible? Do they still come in? Because the child is now unavailable, remember 1325-129 requires that there be corroborating evidence of the act. Corroborative evidence is evidence supplemental to the hearsay statement that tends to establish the facts sought to be proved, or is any evidence, direct or by proof of surrounding facts and circumstances, that tends to establish that the act described by the child in the statement occurred. Some things to keep in mind when you're deciding whether there is corroborating evidence of the act. Number one, you have discretion whether to consider the proffered corroborative evidence and discretion to determine how much weight it should be given. Two, you should examine the totality of the circumstances. Three, you should not base a finding of corroboration on the same facts on which you base your safeguards of reliability findings. Examples of corroborating evidence may include eyewitness accounts, confessions or admissions made by the defendant, medical testimony of abuse, or testimony by a mental health practitioner that the child experienced symptoms of trauma. If you find there is no corroborative evidence, then the statements are not admissible under 1325-129. But if the child victim is unavailable and you find corroborative evidence, then some of the statements might still come in. Because a public defender continues to voice state and federal confrontation clause objections, you have to conduct another layer of analysis regarding the statements. You have to determine whether they are testimonial or non-testimonial in nature. The Supreme Court has determined that statements are testimonial when the circumstances objectively indicate that the primary purpose of the interrogation is to establish or prove events relevant to a later prosecution. Statements are non-testimonial under circumstances objectively indicating that the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency. So let's apply the primary purpose test to the child's statements. Her statements to the friend at school, the teacher who reported the statements to social services, and to the social worker would likely not be for the primary purpose of a later prosecution, unless the social worker accompanied the police officer. The Phillips case held this, as did the Supreme Court in Ohio v. Clark. The child's statements to the police officer and forensic interviewer would likely be for the primary purpose of a later prosecution. So the child's statements to these folks would be inadmissible under the state and federal confrontation clauses. The most important message we can relay is,
many of us have done these hearings repeatedly, so don't hesitate to reach out for help to get questions answered or to even see a sample written order.